apologize, Malaj, and I don't think that the bar should transgress the limits of decorum, which is required, Malaj.
We take up 70 or 80
Malaj, your lordships
80
don't have to
mentionings.
tell us.
I,
Your lordships
yes,
don't have to tell us.
it's
And
a,
Mr. Sibel, actually, for these 80 mentionings, when I say, all right, I'll give you a date in the evening, the staff and I sit through the evening.
Yeah,
They tell me in every
we know,
matter, sir,
true,
this is
my
what has
lord.
happened, somebody's
No, no, it
pencil,
was
some.
the next
Then they'll
the
explain to
next
me the
yesterday
date in
work,
the
the
evening.
next
Then I
day.
give dates in the evening to all the
Malaj,
all the matters.
but I just wanted to say this on behalf of the bar.
that's we all join, my lord.
Thank
We feel equally anguished by what happened, equally anguished and hurt.
Thank you. Thank you, Mrs. Paul. Thank you, Mr. Sibel.
My lords, as promised to your lordships yesterday, I'll now, since my time is curtailed to
Yes.
45 minutes,
Maybe-
I'll stick to four.
Sad.
I'll
Yes.
stick to four judgments. What I've
Right.
done in the meantime is
You got your note.
I've got three things done. The timeline that I gave to your lordships yesterday,
Yes.
the timeline I gave to your lordships yesterday, I've got a note made.
Yes.
The judgments with propositions that I'm relying on, I've got a note made. And the distinguishing note on the judgments relied on by the other side, I've got that note made. So let me just hand it over to your lordships. If your lordships permit, that may be
Excellent.
easier, and then proceed with my
All
argument.
right.
Mr. Courtmaster. This is, my lords, the list of cases we are relying on. Please give one copy to Mr. Sidbal. This side. Then is Mr. Courtmaster. There are two more. Just take this. This is with the letter. So why are you giving with the letter? No. Just do it. Three, four, five. My lords, these are the judgments we are distinguishing. The ones I'm now handing over
Yes.
are the judgments. Please give one, Mr. Sidbal. And lastly, what I am giving to your lordships is the timeline that I relied on, my lords, so that your lordships have in place.
That one place. You've circulated to Mr. Sibel.
Yes, yes, my lords, absolutely. Each of them, as I hand over to your lordships, I'm giving two. And my lords, this consciously not included the EC events, because as your lordship said, that's not something that your lordships are getting into. I pretty much stuck to about the first week of July and stopped to the first week of July as far as these list of events are concerned. So my lords, these three things are done, and I have given. Now, my lords, let me straight away come to the three or four cases that I need to cite, and that's it. Keep the PDF page ready. But one argument, my lords, I just wanted to make before I go to the case law are my submission yesterday for your lordship's
Yes.
kind consideration was that this is an artificial distinction sought to be drawn between a legislature party and political party. It has never been our case at all. In fact, we've right through said that it has the political authority of the political party. They are organically and integrally connected, and they're co-joined, and they have to be seen together. That's how the framers of the Constitution always looked at it. And in fact, whenever an attempt is made to segregate, they say, no, we must look at both. Now, that is further fortified if your lordships were to have para 4 of Schedule 10, which is a defense. Of course, I'm not on the defense argument at all, because according to me, I have not incurred 21A or 21B. So I'm not on the defense at all. But please have that why they should be considered together, and one has a bearing on the other. Please have para 4
That's the important point.
of the 10 schedule.
That should compile. Para 4 of the 10 schedule.
Yes, my lord. May I, with your lordship's permission?
Yes.
A member of a house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with another political party, and he claims that he and any other members of his original political party, and please have two, For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than two-thirds of the members of the legislative party concerned have agreed to such merger. So even when you come to a defense, the bearing of what happens in a legislature party, in fact, they say it's deeming. It's a deeming fiction there as far as the defense of merger is concerned. I'm not for a minute suggesting I'm coming under para 4. I'm just drawing analogy from para 4
Yes.
to say what bearing does the two have on each other. So when you come and say that this is only in the legislature party, nothing has happened in the political party. Whereas even in Rana, which is one of the judgments I'll read out, when the defense was taken up of whether there is a split or not, the question was, should the split only in legislature party be seen or the split in political party be seen? Even there, the Supreme Court said the speaker will not embark on an independent inquiry into whether there's a split in the political party. We'll just take a prima facie view. So they go hand in hand. And this whole argument that you're only the legislature party, not the political party, is a completely wrong argument in law and in facts. Now, my lord, straight away to the judgments. Kindly first have, my lords, Balachand versus B.S. Yadurappa, judgment compilation 3D, volume 3D, PDF page 25, starting at 58.
Don't want to rely upon notes. Straight where you.
But not straight, because this is for all the judgments. I will now just 4 judgments I want to cite and would request your lordship to read with me because that is important for me.
What is that judgment compilation?
Volume 3, judgment compilation, PDF page 58, which is the rel 3.
PDF page 50.
What para did you say,
Judgments
Mr.
compilation volume
113
volume 1.
on page PDF page. May I, with your lordship's permission?
Yes.
The main questions which emerge from submissions made on behalf of the respective parties and the facts of the case may be summarized as follows. A. Did the appellants voluntarily give up their membership of the Bharatiya Janata Party? B. Since only 3 days' time was given to the appellants to reply to the show cause notices, as against the period of 7 days or more prescribed in Rule 7 subclause 3 of the disqualification rules, were the said notices vitiated? C. Did the speaker act in hot haste in disposing of the disqualification application filed by Shri B.S. Yadurappa, introducing a whiff of bias as to the procedure adopted? D. What is the scope of judicial review of an order passed by the Speaker under para 21A of the 10th schedule to the Constitution, having regard to the provisions of Article 212 thereof? The facts of the case reveal that the appellant, along with Shri MP Renukacharya and Shri Narsimha Nayak, wrote identical letters to the governor on 6/10/2010, indicating that as MLAs of the Bharatiya Janata Party, they had become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa. According to them, there was widespread corruption, nepotism, favoritism, abuse of power, and misuse of government machinery in the functioning of the government headed by Chief Minister Shri Yadurappa, and that a situation had arisen when the governance of the state could not be carried on in accordance with the provisions of the Constitution. Accordingly, they were withdrawing their support and their support from the government, headed by Shri Yadurappa, with a request to the governor to intervene and to institute the constitutional process as the constitutional head of the state. The speaker took the view that the said letter and the conduct of the appellants in moving from Karnataka to Goa and other places, and issuing statements both to the print and electronic media regarding withdrawal of support to the BJP government led by Sri Yadurappa, and the further fact that the appellants are said to have negotiated with Sri H.D. Kumaraswamy, the leader of the state Janata Dal, and its members regarding the formation of an alternative government was sufficient to attract the provisions of para 21A of the 10th schedule to the constitution. It was held by the speaker that in the absence of any denial to the allegations made by Sri K.S. Eswarappa, the state president of the BJP, the same had to be accepted as having been proved against the appellants. In this regard, the speaker referred to the views expressed by the constitution bench in Kyoto Holohon, wherein one of the issues which had been raised and decided was the act of voluntarily giving up the membership of a political party may be either expressed or implied. Even greater emphasis was laid on the decision in Ravi S. Nayak, wherein it was observed that there was no provision in the 10th schedule which indicated that till a petition signed and verified in the manner laid down in the Civil Procedure Code for verification of pleadings was made to the chairman or speaker of the House, he did not get the jurisdiction to give the decision as to whether a member of the House had become subject to disqualification under para 21A of the 10th schedule or not. The aforesaid view taken by the speaker has to be tested in relation to the action of the members concerned of the House, and it has to be seen whether on account of such action a presumption could have been drawn that they have voluntarily given up their membership of the BJP, thereby attracting the provisions of para 21A of the 10th schedule. In the instant case, the appellants had in writing informed the governor on 6/10/2010 that having become disillusioned with the functioning of the government headed by Sri B.S. Yadurappa, they had chosen to withdraw support to the government headed by Sri B.S. Yadurappa, and had requested the governor to intervene and institute the constitutional process as the constitutional head of the state. The said stand was re-emphasized in the replies to the show cause notices submitted by the appellants on 9/10/2010, wherein they had inter alia denied that their conduct had attracted the vice of defection within the scope of 21A of the 10th schedule. In their said replies, the appellants had categorically indicated that nowhere in the letter of 6/10/2010 had they indicated that they would not continue as members of the legislature party of the BJP. On the other hand, they had reiterated that they would continue to support the BJP and any government formed by the BJP headed by any leader other than Sri B.S. Yadurappa as the chief minister of the state. They had also reiterated that they would continue to support any government headed by a clean and efficient person who could provide good governance to the people of Karnataka according to the Constitution of India, and it was only to save the party and government and to ensure that the state was rid of a corrupt chief minister that the letter had been submitted to the governor on 6/10/2010. At this point, let us consider the contents of letter 2010 written by the appellants to the governor, which has been reproduced herein before. The letter clearly indicates that the author thereof, who had been elected as an MLA on a Bharatiya Janata Party ticket, having become disillusioned with the functioning of the government headed by Sri B.S. Yadurappa, on account of the widespread corruption, nepotism, favoritism, abuse of power, and misuse of government machinery, was convinced that a situation had arisen in which the governance of the state could not be carried on in accordance with the provisions of the constitution, and Sri Yadurappa had forfeited the confidence of the people. The letter further indicates that it was in the interest of the state and the people of Karnataka expressing his lack of confidence in the government headed by Sri Yadurappa, and that he was accordingly withdrawing his support to the government headed by Sri Yadurappa with a request to the governor to intervene and institute the constitutional process as the constitutional head of the state. Also, it was at pains to point out that the language used in the letter was similar to the language used in Article 356 of the Constitution, which according to him was an invitation to the governor to take action in accordance with the said article. The same is not as explicit as Mr. Sorabji would have us believe. The constitutional process as hinted at in the said letter did not necessarily mean the constitutional process of proclamation of President's rule, but could also mean the process of removal of the Chief Minister through constitutional means. On account thereof, the Bharatiya Janata Party was not necessarily deprived of a further opportunity of forming a government and leadership of the legislature party. In fact, the same is evident from the reply given by appellant 9 reply given by the appellants on 9/10/2010 in reply to the show cause, in which they had re-emphasized their position that they not only continue to support the Bharatiya Janata Party, but would also support any government formed by the Bharatiya Janata Party, headed by any leader other than Sri B.S. Yadurappa as the Chief Minister of the state. The conclusion arrived at by the Speaker does not find support from the contents of the said letter of 6/10/2010, so as to empower the Speaker to take such a drastic step as to remove the appellant from the membership of the House. Now kindly have, my lords, para 142, page 64. My lords have para 142.
Yes.
On the very same day, that is 6/10/2010, Shri Yodurappa, as the leader of the Bharatiya Janata Party, Bharatiya Janata Legislature Party, in the Legislative Assembly filed an application before the Speaker under Rule 6 of the Disqualification Rules 1986, being Disqualification Application number 1 of 2010, for a declaration that all the 13 MLAs elected on BJP tickets, along with 2 other MLAs, had incurred disqualification in view of the 10th schedule of the Constitution. Immediately thereafter, on 7/10/2010, the Speaker issued show cause notices to the aforesaid MLAs, informing them of the disqualification application filed by Shri B.S. Yadurappa and informing them that by submitting letters to the Governor, withdrawing support to the government led by Shri Yadurappa, they had violated para 21A of the 10th schedule to the Constitution and were therefore disqualified from continuing as members of the House. The appellants were given time till 5 p.m. on 10/10/2010 to submit their objections, if any, to the said application. Even if, as held by this court in Dr. Mahachandra Prasad Singh, Rule 6 and 7 of disqualification rules are taken as directory and not mandatory, the appellants were still required to be given a proper opportunity of meeting the allegations mentioned in the show cause notices. The fact that the appellants had not been served with notices directly, but at the same were pasted on the outer doors of their quarters in the MLA complex, and that too without copies of various documents relied upon by Mr. Yadurappa, giving them 3 days' time to file the said notice to file reply to the said notices, justify the appellant's intention that they had not been given sufficient time to give an effective reply to the show cause notices. Please have then para 147 on page PDF 66. 147. May I, Manas?
Yes.
The procedure adopted by the Speaker seems to indicate that he was trying to meet the time schedule set by the Governor for the trial of the strength in the Assembly, and to ensure that the appellants and the other independent MLAs stood disqualified prior to the date on which the floor test was to be held. Having concluded the hearing on 10/10/2010 by 5 p.m., the Speaker passed a detailed order in which various judgments, both of the Indian courts and foreign courts, and principles of law from various authorities were referred to on the same day, holding that appellants had voluntarily given up the membership of the Bharatiya Janata Party by their acts and conduct, which attracted the provisions of para 21A of the 10th schedule of the Constitution, whereunder they stood disqualified. The vote of confidence took place on 11/10/2010, in which the disqualified members could not participate, and in their absence, Shri B.S. Yadurappa was able to prove his majority in the House. Unless it was to ensure that the trust vote did not go against the Chief Minister, there was no conceivable reason for the Speaker to have taken up disqualification application in such a great hurry. Although in Dr. Mahachandra Prasad Singh, this court held that the disqualification rules were only directory and not mandatory, and that violation thereof amounted to only procedural irregularities and not violation of a constitutional mandate, it was also observed in Ravi S. Nayak that such an irregularity should not be such so as to prejudice any authority who is affected adversely by such breach. In the instant case, it was a matter of survival as far as the appellants were concerned. In such circumstances, they deserved a better opportunity of meeting the allegations made against them, particularly when, except for the newspaper cuttings said to have been filed by Shri Yadurappa, along with the disqualification application, there was no other evidence at all available against the appellants. As then please have para 151 at PDF, page 67. This is important. Also on the same page. Well, it's para 152. We cannot lose sight of the fact that although the same allegations as were made against the appellant Shri Yadurappa were also made against Shri MP Renukacharya and Shri Narasimha Nayak, their retraction was accepted by the Speaker despite their views expressed by them upon submitting the letter withdrawing support to the BJP government led by Shri Yadurappa, all the MLAs stood immediately disqualified under para 21A of the 10th schedule to the Constitution, and they were accordingly permitted to participate in the confidence vote for reasons which are not required to be spelled out. Then para 154. Having considered all the different aspects of the matter and having examined the various questions which have been raised, we are constrained to hold that the proceedings conducted by the Speaker on the disqualification application filed by Shri B.S. Yadurappa do not meet the twin tests of natural justice and fair play. The Speaker, in our view, proceeded in the matter as if he was required to meet the deadline set by the Governor, irrespective of whether in the process he was ignoring the constitutional norms set out in the 10th schedule to the Constitution and the disqualification rules 1986, and in contravention of the basic principles that go hand in hand with the concept of fair hearing. As we have earlier indicated, even if disqualification rules are only directory in nature, even then sufficient opportunity should have been given to the appellants to meet the allegation level against them. And kindly now have, my lords, the last para, 157, on same page. The appeals are therefore allowed. The order of the Speaker dated 10-10-2010 disqualifying the appellants on the membership of the House under para 21A of the 10th schedule of the Constitution is set aside along with the majority judgment delivered in writ petition so-and-so and the portions of the judgment delivered so-and-so concurring with the views expressed by Honorable the Chief Justice upholding the decision of the Speaker so-and-so filed by so-and-so. Consequently, the disqualification application filed by B.S. Yadurappa is dismissed. So, my lords, a much worse case, a case where the Chief Minister in question from the same party, they say they have no faith. But they said, where have they said that they are leaving the political party, they are forming a new political party, they continue to support the party. Thus, the extreme conclusion drawn to say that this ex facie attracts 21A is wrong. Because, my lords, if this is going to become the basis of 21A, that I express dissent within the party, then internal dissent, which is the bedrock of democracy and parliamentary democracy, will completely be thrown out of the window. Because at the end of the day, the moment anyone within a party expresses dissent, you say it's a 21A case. So in a much worse case, they said this is not a 21A case. And my lords, I'm not for a minute suggesting, as my lord the Chief Justice said yesterday, my argument is not that the majority within a party cannot attract the 10th schedule. The majority within a party can also disobey a whip or for whatever reasons floor cross or align with the opposition party, go to the governor for falling off the government. That's not my case at all. My case is that to determine who is the rival faction under para 15 of the symbols order, there is an exclusive jurisdiction in the Election Commission of India which looks at the parameters as set by your lordships on Sadiq Ali downwards to see which is the rival faction within the political party to be recognized. And my case right through has been that the legislature party and the political party go hand in hand. You are today seeking to draw an artificial distinction between a legislature party and a political party to say that you have shown nothing in the political party, you've only shown the legislature party. Whereas the legislature party definitely reflects the political authority of the political party as well. In any case, as far as competent body is concerned, it has come to a conclusion that we represent within the Shiv Sena, the recognized Shiv Sena today. So my case is not that a majority cannot incur under 21A. My case is in the facts of the case. For you to say this was only legislature party and not political party is without any basis. In any case, the Speaker has to decide it. You want to bypass the whole route and come to the Supreme Court in an Article 32 and say the Supreme Court must decide before the Speaker, which is in the teeth of Kyoto. And my coming under a 32 was on Nabam, which is on an entirely different footing. That was the argument. Next, my lords, kindly have volume 3D, PDF 787 at page 815. Same volume, I read. That's right, that's right.
क्या page? 787. Tiger 787.
I'm running against time. And 20, but I'd only trouble your lordships with one para since there's less time. Para 19.
Page
815. Lordships may later see both the paras 19 and 20, but I'll only read 19. My lords have 19. The Constitution is not an ephemeral legal document embodying a set of legal rules for the passing hour. It sets out principles for an expanding future and is intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Therefore, a purposive rather than a strict literal approach to the interpretation should be adopted. A constitutional provision must be construed not in a narrow and constricted sense, but in a wide and liberal manner so as to anticipate and take account of changing conditions and purposes, so that a constitutional provision does not get fossilized but remains flexible enough to meet the newly emerging problems and challenges. The reason I'm citing this judgment, my lords, is in the context of Nabam, where it was said that the constitution doesn't provide. As far as this, when does the notice period start? The constitution does not provide for it at all. But some provision will have to be looked at. If a situation emerges when the constitution was drafted and there was no 10th schedule to it at that stage, and a problem arises today, why can the court not interpret it in a liberal manner to take care of the fact that the constitutional values are protected? Right, Manoj? Now please have straight away of vol 5, 6. 14. At 946 at 956.
You're referring to the separate volume?
Which one? Judgment Compilation, Volume 2, Serial number 3.
946.
Yes, which is at 956, para 14.
This is Kuldeep Nair.
In the meantime, starts with in the meantime, my lords. That's
You referring
Kuldeep Bishnoi, my lords.
sorry.
Speaker, Haryana Vidhan Sabha versus Kuldeep Bishnoi.
volume
Page?
2, what page did you say, Mr. 56?
My lords, 946, the judgment starts. The para starts at 956.
Yes.
I'm sorry, I have the wrong volume. Just give me a moment. Judgment
Give my-
compilation.
Give my
volume two.
judgments compilation
Two.
2, huh?
It's serial number 3 of what? 2. Judgment Compilation Volume 2, serial number 3.
This is Kuldeep Bishnoi. No?
That's right. That's right. 946, it starts at 9.
1 second.
950.
Seem to have
So let's see.
gone to Devinder Pal Singh Bullar.
It starts
Huh?
at serial number, it's part 2.
Well, that's the
000.
bookmark 52.
Bookmark 52.
Judgments
Very
compilation
got
2,
it.
na?
Thank you.
390.
Nah,
Yes.
got it.
अच्छा 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 sorry no sorry मेरी गलती हो गई
Kuldeep.
actually.
It's 52 in the bookmarking, isn't it? Is it
956.
Kuldeep Singh Bishnoi? Right. 2015-12 SCC 381, Mr.
Yes.
Well, even if I'm not legally sound, I'm trying to sound technically correct by pointing out all the bookmarks.
No, that's good.
Your Lordship.
You're making progress.
I'm inviting upon myself, Your Lordship. Would Your Lordship be kind enough to have para 14? Yes. In the meantime, proceedings before the Speaker continued, and since the same were not being concluded in terms of the assurances given, the division bench of the High Court directed the Speaker to file an affidavit on or before 11/11/2011. Finally, being dissatisfied with the progress, the pending disqualification petitions before the Speaker, the division bench took upon the letters patent appeals on 2/12/2011 when the directions were given to the production of the entire records of the matters pending before the Speaker. On 7/12/2011, the relevant records of the proceedings before the Speaker were submitted to the High Court, which adjourned the matter till 19/12/2011 for further consideration. However, as alleged on behalf of the appellants, the bench was not constituted on 19/12/2011, and without any further hearing or giving an opportunity to the Speaker's counsel to make submissions on the status report, the High Court proceeded to pronounce its judgment on the letters patents appeals. By its judgment, which has been impugned in these proceedings, the division bench held the direction of the learned single judge directing the Speaker to decide the disqualification petitions within a period of 4 months. However, while disposing of the matter, the division bench stayed the operation of the order passed by the Speaker on the merger of the so it also declared 5 MLAs who have filed separate appeals before this court as being unattached members of the assembly with the right to attend the session only. It was directed that they would not be treated either as part of INC or HJC party, with a further direction that they would not hold any office either. It is aforesaid directions and orders which have resulted in the filing of several special leave petitions before this court by the Speaker and 5 MLAs. As a consequence of the order of the Speaker, consequence of the order passed by the division bench of the High Court, the 5 independent appellants before us have been prevented from discharging their functions as members of the Haryana Vidhan Sabha even before the disqualification petition filed against them by Shri Kuldeep Bishnoi could be heard and decided. Then para 46, my lords, on page 965. Last para on that page, para 46. My lords have that? The appeal filed by the Speaker of the Haryana Vidhan Sabha against the judgment of the division bench of the High Court is not therefore capable of being sustained, and the appeals filed by the Speaker is accordingly dismissed. The other appeals preferred by the 5 disqualified MLAs have therefore to be allowed to the extent of the directions given by the learned single judge and endorsed by the division bench that 5 MLAs would stand disqualified from effectively functioning as members of the Haryana Vidhan Sabha till the Speaker decided the petitions regarding their disqualification within a period of 4 months. In our view, the High Court has no jurisdiction to pass such an order, which was in the domain of the Speaker. The High Court assumed the jurisdiction which it never had in making the interim order, which had the effect of preventing 5 MLAs in question from effectively functioning as members of the Haryana Vidhan Sabha. The direction given by the learned single judge to the Speaker as endorsed by the division bench is therefore upheld to the extent that it directs the Speaker to decide the petitions for disqualification of the 5 MLAs within a period of 4 months. The said direction shall therefore be given effect to by the Speaker. The remaining portion of the order disqualifying the 5 MLAs from effectively functioning as members of the Haryana Vidhan Sabha is set aside. The said 5 MLAs would therefore be entitled to fully function as members of the Haryana Vidhan Sabha without any restrictions, subject to the final decision that may be rendered by the Speaker in the disqualification petitions filed under para 6 of Schedule 10 of the Constitution. Now, my lords, this is of course the same principle as in continuation with Shivraj Singh Chauhan, which I had read out to your lordships.
Yes.
And there was a question that your lordships had put to me on the day before yesterday, that could someone say that Shivraj Chauhan was only on resignation. That's why I read out those paragraphs that Shivraj Singh Chauhan, your lordships don't just deal with resignation of MLAs. Your lordships categorically in paragraphs 78 to 81 talk about disqualification petition under the 10th schedule. And say if disqualification petitions under the 10th schedule are pending, doesn't mean in the meantime they will stop discharging their functions as a member of the House. My next judgment for your lordship's kind consideration, my lords, is Rajendra Rana.
That would be judgment's compilation.
No, my lords, now on a point that I'm relying on. Till now, I distinguished on what they were relying on. They were relying on it for two purposes: ex post facto, and that your lordships as a court of first instance can decide. Ex post facto, I explained to your lordships saying that it was qua the Speaker, that the events to be seen by him were on the day when they incurred disqualification, not subsequent events or split. And as far as your lordships deciding as a court of first instance was on an issue where it had been there in the High Court for 3 years, then the High Court remanded it back. When it came to the Supreme Court said the assembly election, the term is to expire by the end of the year. So let's decide the matter. That is quite different from this matter in every which way. Now, my lords, kindly have Judgment Compilation Volume 1, bookmark 19, page 834. Context of that exposed word. These two.
Para?
Para 25 on page 855. My lords, before I start, let me tell you, lords, the context why I am citing this judgment.
Para 25. PDF 855.
My lord, the Chief Justice.
855.
Yes.
My lords, the reason I am citing this judgment is that in this, at that time, para 3 as a defense was available. At that time. Even when para 3 as a defense was available, the Supreme Court said that the Speaker deholds disqualification, does not embark on an independent inquiry to find out about splits in the political party. He only takes a limited prima facie view of the split within the political party. The reason I'm citing is even when this is not a question of merger, but even where it was a question of split and para 3 was still on the statute book, the court said the speaker will not embark on an independent inquiry into splits in the political party. Please have para 25 for a minute, my lords, on page 855.
It is only a jurisdictional fact for him to enter to give a finding with respect to disqualification.
Grateful. Grateful. That's all. I couldn't have put it better. That's all. My lords, may I?
Yes.
Yes.
25. In the context of the introduction of sub-article 2 of Article 102 and Article 191 of the Constitution, a proceeding under the 10th schedule of the Constitution is one to decide whether a member has become disqualified to hold his position as a member of the Parliament or of the Assembly on the ground of defection. The 10th schedule cannot be read or construed independent of Article 102 and 191 of the Constitution and the object of those articles. A defection is added as a disqualification, and the 10th schedule contains the provisions as to disqualification on the ground of defection. A proceeding under the 10th schedule gets started before the Speaker only on a complaint being made that certain persons belonging to a political party had incurred disqualification on the ground of defection. To meet the claim so raised, the members of Parliament or Assembly against whom the proceedings are initiated have the right to show that there has been a split in the original political party and then they form 1/3 of the members of the legislature party, or that the party is merged with another political party and hence para 2 is not attracted. On the scheme of Article 102 and 191 of the 10th schedule, the determination of the question of split or merger cannot be divorced from the motion before the Speaker seeking a disqualification of a member or members concerned. It is therefore not possible to accede to the argument that under the 10th schedule to the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party as contemplated by para 3 and 4 of the 10th schedule to the Constitution. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But this is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim being determined by him that a member or a number of members had incurred disqualification by defection. To that extent, the decision of the Speaker in the case on hand cannot be considered to be in order in terms of 10th schedule of the Constitution. The Speaker has failed to decide the question. He was called upon to decide by postponing a decision thereon. There is therefore some merit in the contention of the Learned Counsel for BSP that the order of the Speaker may not enjoy the full immunity in terms of para 6 subclause 1 of the 10th schedule to the Constitution, and that even if it did, the power of judicial review recognized by the court in Kehoto Holohon is sufficient to warrant interference with the order in question. In a sense, this aspect may not be of great importance in this case, since going by the stand adopted on behalf of 37 MLAs, the Speaker was justified in keeping the petition seeking disqualification of 13 MLAs pending, even while he proceeded to accept a case of split in BSP. The question really is whether the Speaker was justified in doing so. As we have indicated above, the whole proceeding under the 10th schedule to the Constitution is initiated or gets initiated as a part of disqualification of a member of the House. That disqualification is by way of defection. The rules prescribed by various legislatures, including the UP legislature, contemplate the making of an application to the Speaker when there is a complaint that some member or members have voluntarily given up his membership or their membership in the party. It is only then that in terms of 10 schedule, the Speaker is called upon to decide the question of disqualification raised before him in the context of para 6 of the 10 schedule. Independent of a claim that someone has to be disqualified, the scheme of the 10 schedule or the rules made thereunder do not contemplate the Speaker embarking upon an independent inquiry so as to inquiry as to whether there has been a split in the political party or there has been a merger. Therefore, in the context of 102 and 191, the scheme of the 10th schedule to the Constitution, we have no hesitation in holding that the Speaker acts under the 10th schedule only on a claim of disqualification being made before him in terms of para 2 of the 10th schedule. And now, my lords, kindly read this with para 37, and then I'll come back to one more para I need to show. Please first have para 37. PDF page 862, my lords. My lords have para 37.
Yes.
Thus, in the above decision, it has been clarified that it is not enough that a claim is made on a split in the original party, in addition to showing that 1/3 of the members of the legislature party have become out of the party, but it is necessary to prove it at least prima facie. They say prima facie, yes, but all the time emphasizing on this whole thing that the Speaker will embark upon a full-fledged inquiry into the political party, the talukas, the districts, and decide on a split in a political party is without jurisdiction. Quite apart from the fact that you're seeking to draw an artificial distinction which does not exist. And I'll come to that judgment. That para of Sadiq Ali, I'll show to you, lordships, which is important for this. Now, my lords, kindly have, only for that other issue of ex post facto, I'll just sum it up on para 34 of the same judgment. I just need to show that.
Here comes the test. The test is here.
Yes, yes. 860. 860. Para 34. My lords have that?
Yes.
As we see it, the act of disqualification occurs on a member voluntarily giving up his membership of a political party or at the point of defiance of the whip issued to him. Therefore, the act that constitutes disqualification in terms of para 2 of the 10th schedule is the act of giving up or defiance of the whip. The fact that a decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislature. Similarly, the fact that the party could condone the defiance of a whip within 15 days or that the Speaker takes decision only thereafter in those cases cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. Therefore, in the background of the object sought to be achieved by the 52nd Amendment of the Constitution and on a true understanding of para 2 of the 10th schedule with reference to other paragraphs of the 10th schedule, the position that emerges is that Speaker has to decide the question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies the whip. It is really a decision ex post facto. It is in this connection that the observation is made that subsequent facts of split, seeking a defense of split under the 10th schedule will not be looked at. You will see on the day you went to meet the governor in the facts of this case, some of the MLAs with the opposition party and asked the Samajwadi party to form the government was an act which was squarely hit by 21A. And that is why, my lords, I had respectfully submitted and read out instances of Ravi Nayak of this judgment. They were overt acts under 21A. Yadurappa's judgment clearly says merely because within the party I say I do not support a particular coalition of a government is not a 21A case at all in the matter. In any case, my lords, who will decide it? Whether it's a 21A case or a 21B case, it still has to be the Speaker under para 6 who's the sole and exclusive constitutional authority to decide it. So A, I'm not a 21A case. B. Yadurappa is held merely because you show support to a government is not a 2-1A case. And thirdly, my lords, in facts of these cases, the facts which have to be seen are the facts on that date. The ex post facto is in that context. Ex post facto doesn't mean that since your disqualification will be decided on the date you incurred it, all your acts as members of parliament or members of the legislative assembly get annulled in the process. And that is the deduction sought to be drawn now from the words ex post facto in Rana's judgment. Now, my lords, kindly have, just last two judgments and I'm done. Kindly have Rameshwar Prasad versus Union of India. Same volume, bookmark 16, para 165. Relevant para 165 is at page 521.
What's the, sorry, page?
PDF page.
Uh,
Same?
PDF page 521.
Same compilation?
Same volume,
PDF is 390.
521. My lord, sir, para 165. May I, my lords?
Yes.
If a political party with the support of other political party or other MLAs takes a claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. Governor is not an autocratic political ombudsman. If such power is vested in the governor or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power of 356. Remedy for corruption or similar ills or evil lies elsewhere and not in Article 356. In the same vein, it has ought to be held that power under 10 schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10 schedule is of judicial nature. Dealing with question whether power of disqualification of members of the House vests exclusively with the House to the exclusion of the judiciary, which in Britain was based on certain practices of the legislature, as far as concerned, it was said in Quixote, it is therefore inappropriate to claim that determinative jurisdiction of the Speaker or the Chairman of the 10th schedule is not a judicial power, is within the non-justiciable legislative area. So the reason I'm citing this judgment, my lords, is for the fact that for A, of course, we say that the chief minister lost his majority. The coalition government could not survive. We within the party were the overwhelming majority. And even if their argument was to be accepted, which I'm not conceding, that, oh, you cobbled it up together in an illegal mean, etc., which it is not. It was a perfectly legitimate government which was sworn in. The governor is not to sit on these matters and make his assessments if a probable, plausible coalition or partnership comes before it and says, because ultimately at the end of the day, someone has to head a government, my lords. My lord, the Chief Justice posed a question to me yesterday. After the sitting Chief Minister resigns, someone has to be sworn in. Now, if a set of people come and show that they have a sizable or an overwhelming majority, he says, go and test it on the floor of the House. And what time does he give? 2 days to do it. And your lordships have normally said those cases where you're given a month, 2 months, and that is scope for horse trading, etc. He immediately calls for a floor test in exercise of his constitutional duties and obligations and say, prove your majority. If you are the new government which is taking its claim within the same political party, now in coalition with another political party who's a pre-poll ally, what is wrong with that decision of the governor within 2 days? Now, my lords, kindly have lastly, Sadiq Ali for a completely different proposition. Volume 2, volume 2, bookmark 39,
Same volume.
PDF 85 at 98. Can we repeat that? Volume 2,
Bookmark 39
bookmark 39.
starts at PDF page 85 to
The judgment starts at page PDF 85,
relevant para at PDF 98.
relevant para at PDF 98.
Para?
98, para 27, page 98. Well, before I proceed to read, my Lord the Chief Justice, can I? Before I proceed to read the judgment, my Lord, the reason I'm citing it is I right through said, apart from all other arguments, that you cannot segregate the two. One of the principal arguments for recognition of a political party under 6A and 6B of the symbols order, those provisions I have not read, of 6A and 6B for a continued recognition and recognition of a political party is the number of percentage of votes polled by MLAs, MPs, its strength in the House. These are all relevant factors. So what happens in the legislature can't be just kept aside. That's a relevant consideration within it. So to say that they're two completely distinct things and political parties distinct and legislature parties distinct is not correct. And that is what Sadiq Ali also notices in this paragraph is what I wanted to show it for. The other paras, my lords, I'm not bothering your lordships on all those powers of the EC because we are not getting into that. It may be mentioned that according to para 6 of the symbols order, one of the factors which may be taken into account in treating a political party as a recognized political party is the number of seats secured by that party in the House of People or the state legislature. Assembly, or the number of votes polled by the contesting candidate set up by the party. The number of seats secured by a political party or the number of votes cast in favor of a candidate of a political party can be a relevant consideration for recognition of a political party. One is at a loss to understand as to how number of seats in parliament and state legislatures held by supporters of a group of political party can be considered to be irrelevant. We can consequently discover no error in approach of the commission in applying the rule of majority and numerical strength for determining as to which of the two groups of Congress J and Congress O was the Congress party for the purpose of para 15 of the symbols order. Now that is a separate matter which your lordships are dealing with, where this has also become one of the considerations. And this para of Sadiq Ali in that other matter that your lordships are dealing with. That this is one of the indicators, valid indicators available. So to come and say that you've only done it in the legislature party, there's nothing in the political party. And their entire argument, my lord, was, with great respect, that on 18th you had a meeting and you showed the minutes of 27th. It's factually wrong. I'll argue it in there in that matter. They're two separate meetings. They're factually incorrect statements made that you had a meeting on the 18th, but there are no minutes, there are no signatures. That's not the subject matter of the reference before your lordships at all. And I'll argue it there. There are two separate meetings. Requisite members attended it. And please do not confuse the minutes of one meeting with the holding of another meeting. My lords, I'm very, very grateful. Your lordships have been extremely kind and patient. I'm extremely grateful, my lords, and the 3 notes I've given. I'm extremely grateful.
Thank you, Mr. Who will now argue? Mr. Jetnani will argue.
I'm told Mr. Salve is logged in, so he'll just make a brief submission first.
Who's your parent?
Sir, you are not audible, sir.
Hear me now?
Yes, Mr. Sarve.
Yes. My lord, a short submission. I mean, Mr. Kaul has addressed your lordship on issues which perhaps don't arise really, if your lordship sit back and consider. What is it that your court is called to decide today? I mean, we have answered everything on merits, but my lord, if your lordship take a step back and see what is it that your lordships need to decide. The first step in this entire saga
Mr.
was...
Sarve is appearing for whom?
Mr. Salve, who do you appear for?
Yes, I'll just give your lordship the numbers.
Sorry, who are you appearing for?
Yes.
So the same set of parties.
There are many respondents.
So different respondents.
Yes, we have
Multiple
all
Same,
respondents, yes.
another set of petitions.
Really, we have to only distinguish the case of the governor because the governor will be represented by
The solicitor, yes.
Whose client is not colored in any case. There is no confusion about whom I appeal.
And the rest of Mr. Kaul, Mr. Salve, Mr. Jetnani, Mr.
We'll give appearances.
for the individual
Yeah,
party.
that's right.
Fair enough, no problem.
Respondents. Okay.
And my lord, the only thing I wanted to broadly respond to is Mr. Sibal's broad submissions about what role the court should take onto itself to prevent political immorality. But this is a very slippery slope. And your lordships have always resisted the temptation in certain areas to go beyond a particular point. Interpreting the 10th schedule undoubtedly will be inspired by the objects of the 10th schedule, namely to bring in a degree of political morality in public life. But beyond that, my lord, I would submit for the court to embark on this journey would be extremely perilous because there are very delicate balances between institutions involved here. Mr. Uddhav Thackeray resigned. The governor called for a floor test of a sitting chief minister. There was no floor test held. The submission is if he had not called for the floor test and if this had happened and if that had happened, he would have won the floor test. A submission which your lordships should not even countenance for the reason we do not know what happens in that part of the world when it comes to defending the majority of a chief minister. And my lord, it becomes even more perilous in today's day and today's world of coalition politics. How do you know who would have supported whom on that momentous day? What if one of his coalition partners had said, sorry, I can see that you've really lost support of your party. We don't want to support you anymore. We don't know. And it is not for us to understand because these are matters beyond our understanding as lawyers. So, my lord, this entire submission that your lordship must assume a state of facts would have prevailed is extremely hazardous because this is in the realm, my lord, not of legal fiction. This is in the realm of the rough and tumble of politics. And I'm not suggesting any political immorality. My lord, why can it not be that two coalition partners say, we will not support you anymore. We've lost faith in your ability to steer the ship. We don't know whether that would have happened. Would it have happened? Would it not have happened? How can your lordships be invited to hazard that guess that if this had not happened, the but-for test, my lord, which we call in our in commercial law for breach, the but-for test cannot apply here. Yes, if Mr. Thackeray had contested the floor test, if he had lost by 10, and your lordships felt 16 disqualifications were affected, the court could have said, we need to fix this problem because of our refusal to grant the test, because your lordship said we will not stay the floor test. We will make it subject to our judgment. And your lordships would have been in a position to correct what went wrong. My lord, I know it's a much more mundane world in boardrooms and in company general meetings, but the principle is the same. Somebody says so-and-so should not be allowed to vote. Your lordship said count his vote separately and we'll see what happens to the resolution. And the reason is, my lord, suppose he had contested the floor test and lost by 70 votes. All this becomes academic. Yes, if they have defected, is the sin of defection purged? Maybe not. So, my lord, that's the first point which I wanted to make. If that has happened, then if I'm right there, that your lordship cannot and should not embark on any but-for assumptions here. Because we do not know what would have happened on that fateful afternoon. Please, my lord, consider another scenario. I'm only giving these not because I'm saying this would have happened. I'm saying this could have happened. Only to persuade your lordship not to go down this road. Let's take another scenario. These 16 were guilty of an overt act. They did not show up for a meeting. Somebody says that constitutes abandoning your party. Another 20 people may have done something by which you say they have done an overt act. What do you know is lurking in the minds of others? Look at what happened, and I'm just to buttress this point, Manoj, look at what happened when Shinde came for his floor test. 13 of hardcore so-called supporters of Mr. Thackeray abstained from voting, which basically meant it strengthened his hands. Now, these things happen in public life. How do you know how many more were not harboring the intention of walking away that day? So, Malad, these are all I'm saying is this is rank speculation as far as we are concerned. The politicians may feel that they knew what was going on. And we've had, and I'm just bringing it to your lordship's notice, your lordship know this, we've had a very strange situation in this very state, in this very formation, where one government was sworn in, and within 3 days that government fell and another government had to be sworn in. So, but these things happen. And the person who got sworn in as the deputy chief minister with another formation became deputy chief minister. These fast-moving political waters take different turns at different points. We are not to speculate about them. Now, if I am right there, then Malad, that should be the end of the matter. What is the speaker's constitutional obligation? The general Bomai principle, which your lordship has been shown in para 395 of Bomai, is that please, Mr. Speaker, do not do a mathematics. And Mr. Governor, please do not do this mathematics of but for. Call for the floor test. Let this be decided on the floor. My lord, when governors have sacked governments doing head counts, your lordships have taken him to task saying you're failing in your job. Why? Because it is not for the governor to count heads. What Mr. Sibal and Dr. Singhvi are trying to do is persuading your lordships to count heads. Because unless you do a head count, your lordship must then come to the firm conclusion that but for these, Uddhav Thackeray would 100% have won. That's head counting. So, my lord, what your lordship said the governor shouldn't embark upon, now the judiciary is being asked to embark down that road. Nothing can be more perilous than that, is my submission. Yes, we have a problem. We have a problem. We have the 10th schedule. Is the 10th schedule a perfect solution? No, it's not. It has its leaks. Parliament is, when the legislature sometimes tries to fix it, sometimes there are conflicting interests, it is not fixed. Malad, the biggest example we have of criminalization in politics, we've had this problem all the while. We have problems about election donations, we have problem about election funding, we have problem about election spending.
Stature versus stature.
These are all problems, Malad, we can't cross beyond a point. So, Malad, first of all, I submit the first set of cases don't arise. Then comes the second situation. What did the governor do? He is left in Maharashtra without a chief minister. If he is left in Maharashtra without chief minister, he has to invite somebody to form the government. Now, he had then two options. He has invited Mr. Shinde to form the government. Should he have allowed Shinde to continue without a floor test? That would have been worse than conducting a floor test. Where are we in this case? Everything is academic. Yes, the only thing which remains is the 36 pending disqualification petitions which the speaker will decide. And if he gets them wrong, there is a high court which will correct them. Your lordships are here which will correct them. We have, within the parameters of judicial review, your lordships have tested and corrected these orders time and again. That is, my lord, my first submission. My second submission. is what happens pending the disqualification petitions. Your Lordship has been shown the judgments, but my Lord, sometimes it helps. Let's go back on first principles. Please see two provisions of the Constitution, my Lord, and whether your Lordships find the answer there. 190.
Yeah, we've seen that actually.
Your Lordship has seen it.
We've seen it.
Correct, my Lord? The point which I wanted to make is just show your Lordship something in the language of 190. Just for 2 minutes.
190 is Parliament. We are more concerned about 180. Is that
69.
160?
The language is identical. I mean,
Identical.
yes, there's no. The principle of the two is very important. Let's see the compare the equivalent provisions. First see 173. These are qualifications. Person not qualified to fill a seat. I don't need to talk about the details. And then we come to 190, which is houses of the state of legislature. So we are really concerned with 190 because we are talking about state. And 190 sub-article 2 tells your Lordships, no person shall be a member of two or more specified, then after the expiration of the period, etc. We are not concerned because we are really concerned with sub-article 3A becomes subject to any of the disqualifications in 1 or 2 of 19 of 191. So we may not go to 191. 191 applies to at both stages for being chosen and for being a member. We see our post occurrence of events. Unsound mind and stand so declared by competent court. A pendency of a petition in a court to declare somebody incompetent is not good enough. In pending insolvency is not good enough. Look at E now. If he is not so disqualified by or under any law made by Parliament. Now, my lord, today your Lordship was told eloquently of how terrible it is to allow those hit by 10 schedule to continue. My lord, it is not every time that there is corruption because of which there is defection. There may be times where people may defy a whip. There may be time when there may be a split in a political party. Now that sub-article 3 has gone, you have a problem. And people may say, we will brave disqualification, but this chief minister has to go. But look at, my lord, the Representation of People Act. You may have a person who's elected on which there are allegations of booth capturing, of violence. I remember, my lord, once somebody was arguing the case for one of the persons from Bihar, my lord, who was in jail and saying he should be allowed to come. Mr. Tulsi was arguing and he told Justice Nanavati, he said, see the majority by which my client has won the election. And Justice Nanavati said, if your client had his way, he would have had no opponent. He would have killed all of them. So, my lord, those kind of cases are pending. A person, my lord, a known mafia king, against whom there was a murder trial pending for publicly gunning down people, continued in office.
Where does it?
my lord, we have cases, and your lordships have dealt with these cases in the High Court, sometimes in appeal in this court. You have cases of the worst kind of electoral offenses pending for trial. What happens to those people? They continue in office. So, my lord, there is nothing so shocking that in our system, many times people continue in office where there are serious allegations pending against them. That's the bane of our system.
Thank you.
Thank you. Thank you, Many.
Now, with that, my lord, see the language of 191.2. A person shall be disqualified for being a member if he is so disqualified under the 10th schedule. So that disqualification must take place. And that disqualification in the 10th schedule does not take place until there is a decision of the chairman or the speaker under paragraph 6. Any other view, my lord, would be equally or would be far more disastrous, because today all you have to do then to paralyze the working of an assembly is to file disqualification petitions.
Mr. Salve,
Yes,
till here there is no problem.
yes,
The position under the Constitution is very clear,
yes,
and also the judgments of this court.
correct.
Concluded with this expression, the decision.
Yes,
The problem arises the time, context, and the stage at which speakers choose to take a decision.
yep. I was going to straight away address, but
Where are
yeah.
we?
So
I mean, in that,
yes,
it is in that context that
yes. Now, my
either
lord,
that
may I-
either that he shows over anxiety to immediately decide violating principles of natural justice, or he just doesn't decide for times to come.
my lord,
So,
the
in
short
the case
answer,
of pending 10th
yes,
schedule proceedings,
yes,
the powers to be exercised either by the governor or the political process, as it were, goes on.
yes.
So makes the application redundant
My
many a
lord,
times.
may I, my lord, respectfully
Please
answer?
also.
This has been the biggest problem of appointing a speaker. Mr. Sibal was right when he said, your lordships express hope and faith that the institution of the speaker will rise above politics when it comes to the 10th schedule. Our experience may not have fully risen up to those expectations, but that's where we have to drop that. The point, my lord, is this:
Yes.
But not the respectfully answering Justice Narasimha's question. If your lordship has seen, the rules here have in one sense a constitutional status because the rules are framed as a delegate under paragraph 8. And those rules can and should provide a time frame in which these petitions have to be decided, both giving fair opportunity. So these rules normally say you will give so much time for giving a reply. One of the reasons why our group came to court is even that time was not given. And equally, perhaps its time has come for the rules to say, if a petition is filed, he shall, unless there are compelling reasons to the contrary, dispose it off in 90 days or 60 days or something like that. And there, my lord, then judicial review will come in. If a speaker is dragging his feet and the rules say he must decide it absent compelling reasons within a given frame of time, judicial review will come in. You can go to a high court and say, issue a writ of mandamus directing him to dispose of, because then you will have a legal right to ask for a decision within a given time. So, my lord, these are the only ways in which your lordships can address these lacuna. Now, what is the relating back? Relating back has two dimensions. The event has taken place. So ultimately, subsequent events will not affect, it will not efface the wrong which you have committed, the political wrong which you have committed, which disqualifies you. It's over. My lord, if you enter into an office of profit, you're disqualified. If you resign 3 months later from that office of profit, it is not saved. You're disqualified on that day. So, my lord, that disqualification is based on a set of events. But please consider the consequences, which will be contrary to the terms of the Constitution, which says no act of the House shall be declared invalid merely because a member participated who was not entitled to. Now, first of all, here you are entitled to participate, but even if a wrong person comes in, you cannot go annulling the work being done. Today, my lord, when the defection petitions are if some of them are allowed, in between laws have been made, resolutions have been passed by the House, all of them can't be revisited. So, my lord, that's the respectful answer to the ex post facto point. That as a matter of law, and my lord, I read, since your lordships have kept this question back.
What were you saying, Mr. Sarvi, as a matter of law?
As a matter of law, my lord, I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Let me explain what I mean. The speaker
On
is
the ex post, Mr. Salvi, in a sentence, can you just summarize your ex post facto on facto? What is your, so we'll just, if you
yes,
formulate it, we can take it down
yes,
then,
my formulation of ex post facto is as follows. The disqualification will have to be decided on the basis of the acts and omissions of the allegedly delinquent member on that date. But subsequent events will not cure that. the most serious allegations of having been elected by wrongful means such as booth capturing, threatening witnesses, or rampant corruption in election also continue in office. That's one of the banes of our system till such time as a election tribunal declares them to be wrongly disqualified. That's the way it is. So, my lord, my respectful submission is that yes, the rule should be amended. Speaker should decision making should be made time bound. Judicial review will be available where a speaker is holding back. All those are ways which we can fix this. But my lord, the legal consequence of the pendency of these proceedings and its ultimate decision, this is the principle of ex post facto which must apply. No less, but no more.
Anything else, Mr. Salve? We got the
Yes.
ex post facto.
Third point which I wanted to make, my lord, is since the point is still in play, the Nabam Rebia judgment, and I had, my lord, given a note earlier. I believe Mr. Trivedi had handed it over. Mr. Jetmalani had handed it over.
Last time you read also when you appeared.
Yes, my lord. No, after that I gave a note, my lord.
That was there.
I read the judgment as more not the absence of power, but the manner of its exercise. So it is by filing a disqualification or rather a removal of speaker, because all those provisions are shown to your lordship saying the speaker doesn't, as a matter of law, is not put in suspension. They are right. So there is no absence of power. I was not only saying.
It's about the manner of exercise rather than the absence of power.
Correct. Because, my lord, abuse of constitutional power is a head which we now recognize for judicial review. Is my lord the Chief Justice saying something to me, my lord? I can't hear.
You don't read Nabam Rebia as an absolute principle that the speaker is disabled from exercising his jurisdiction when there's a motion for his removal pending.
No.
It's a caution to the speaker, and ultimately it's for the speaker to take a call whether there's a frontal assault on his continuance, whether he would like to go ahead with the hearing of the disqualification petition.
And as I read that judgment, my lord, your lordships have not said that the speaker ceases to have power, but the
So what you're
manner
telling
of
us would be either to sort of restrict it a little bit or put a gloss on the judgment. I mean, if you really read those,
my lord, we always judgments are not statutes, and we always want to learn to understand them. Sometimes when things are written, my lord, those facts were very stark, so maybe the language used was a little strong. But I read that judgment as, because please see, my lord, the analysis, and your lordship has read the judgment. I'm not going to waste your time reading it. The facts were so stark. What really your lordship was doing is that are saying is that the speaker had no business to do this. The actions of the speaker in that case, my lord, were open and shut case of abuse of power, is the finding. So I don't, my lord, read that judgment as absence of power. Your Lordship never said that he ceases to have. There are 50 other things the Speaker does, my Lord. He runs the whole administrative office of the legislature. Surely he's doing all that. It's only in one area that the Speaker should not act. If there is, my Lord, pending consideration of all these rumpus, if there was any other resolution, of course he would preside and run the House. So, my Lord, once your Lordships read that judgment that way, that what really the court was trying to say is not an absence of power, but the actions of a Speaker will be tested. A Speaker should be put to caution when there is a notice for his removal. His actions will be tested on well-known principles of abuse of power. Then, my Lord, the concern which your Lordship have would go away, with that judgment being read as absence of power. And finally, my Lord, if I may just hark back a little to my first opening point, apart from this understanding of the Navam Rabia judgment, my Lord, nothing else really survives. There is a note which I believe is placed at note J. My Lord, I believe, I'm sorry, my friend informs me, my earlier note saying what I have just formulated for your Lordship's consideration is in note F. And there is yet another note, note J. Yes, this is only to show the hazards of the but-for test.
Note J.
I was just told, my Lord, it is marked as note J.
It is written submissions. It doesn't say note J.
It's just brief note on arithmetic for hypothetical trustworthy.
What's that?
Mathematics.
Yes, it's just the math. Only, my Lord, this is only to indicate to your Lordships that this but-for test is extremely hazardous. To guess what would have happened on that fateful day had a trust vote taken place is inviting rank speculation.
I got it. Harish Salve's mail.
F is the earlier one on the Constitution bench judgment, the Navam Rabia judgment.
दोपहर को कर दे दोपहर को हाँ कर दे
हाँ.
हाँ प्लीज
And this note J, my Lord, only sets out, I'll quickly tell your Lordship what we have basically said.
Notes तो तेरा
नहीं है वो अलग है
I have given, my Lord, different places where in the writ petitions they have mentioned
You sent it on my mail, personal mail, na?
basically, my Lord, this gives you at one place. Please, it's not there, there's no big deal. Your Lordship knows it is there. Basically, what we are trying to say is, we have given your Lordship the para numbers and the page numbers.
तो डाउनलोड कर देना बाद में उसको
Thank you.
If your Lordship sees the from paragraph 3,
नहीं.
Email ID please.
on 23rd June, only 16 disqualification petitions were filed. Let's be very clear, my Lord, of a few dates. On 25th June, Speaker issues notice to 16. The order of your Lordships on 27th June was limited to 16. The suggestion
नहीं आया. अच्छा.
that, my Lord, there was 39 or 40 disqualifications. In fact, my Lord, look at 4C. There are two of them who are independents. They may vote one way or the other. Their party, so their party to decide whether they consider it a breach. no prayer in any of the petitions that 39 or 40 should not be allowed to vote. So, my lord, these figures which are being given, and I've given your lordship the shifting stands in different places. And I, my lord, again underscore the point. This was only
Mr. Salve, Mr. Sybil, Mr.
To
Kaur,
finish,
Mr.
Malas,
all of you.
this.
What you were thinking was that Mr. Salve, roughly,
I'm done in 5 minutes.
That's all right. But it won't finish now.
Yeah.
Can't finish. There's no point.
Mr.
Malas.
Salve, you will take about
5-7 minutes.
5 minutes.
I'll be done by
Okay,
lunch.
5,
Yes,
7 minutes.
100%.
Mr. Jethlani, we are not at all rushing any one of you because these are important matters of moment. We are not just forget the facts, but we are thinking of a matter of a moment. So, how much would you take in terms of
Ordinary circumstances, about half an hour, but I could curtail it to 20 minutes, 25 minutes.
half an hour? Then, Mr. Maninder Singh, half an hour, all right. Mr. Solicitor,
Are a few more minutes, my lord.
what you will between the three of you will take 2 hours.
Realistically speaking, it may not be over.
All right, Mr. Call, one more thing. I thought we curbed you unduly, and then you were gracious enough to follow our edict. But the idea was to finish today, but we may not be able to wrap up today.
Yes, yes,
It doesn't
no
appear that we'll be able to wrap it up today. In which case,
Then
Mr.
let's
Kaul,
have
are
it
you-
on Tuesday then, Malas.
Mr. Call, one more thing. Is your conscience clear that you are satisfied that you've argued fully? Is there something which you would have still liked? Because as a judge who's seen so many seasons,
Never give
I
that
don't want you to
opportunity
leave.
to a lawyer, Malas.
You don't want to give the impression that you're not.
Ideally, I would have liked to take your lordships through some of the judgments if I could, which I read, but what do I say, my lords, to this? I can't. I leave it to your lordships. I can't say.
All right. What we will do is this: we will hear Mr. Salvi now, just wrap it up, or we can. क्या करें?
Well, let's wrap it up and then have it on Tuesday, Malas, after
Tuesday,
reopening. That's the only way, Malas.
On the reopening. Reopening.
Then do is that on Tuesday,
On reopening.
after we reopen, the three of you who have to now argue, and honestly, if there's something you want to still show us in the morning after Mr. Salve has wrapped up, we'll give you a little time so that you don't feel that
Very.
And anyway, there's no prejudice to Mr. Sibal because you still have to rejoin. So
Yes, yes, now, Malas, I'll sort of rejoin without the
would
haste.
would it be all right to assess that on Tuesday in the first session, the three of you will be able to finish?
Yes. Yes.
Right? Maybe so. If you take.
But are we not continuing this afternoon also?
I think
No,
there's
no
point
need,
because
Malas.
they're now spilling over beyond the.
Yes.
There's no
So then
point
we'd
in
get
that,
some more time also if it was full.
isn't it? Then what we can do is we can keep it on Tuesday. Mr.
Yes.
Sarve, we'll hear you for 5 minutes on Tuesday.
Yes, yes.
You may want to just.
Very well.
And then, Mr. Paul, if you still want to make a few submissions in your judgment, no problem. We'll hear you on that because let's not go.
They're very kind of your lordships. Very kind.
Then Mr. Jeffnani and Mr. Maninder
not
Singh,
repeat
and then we'll hear the
anything.
governor, Mr.
After, my lord,
Tushar Mehta.
So-
And equally, Mr. Sibbal, we'll give you a full.
That's right, Malas, because there's lots of things that have been said, Malas, which
Mr. Sarode, what is that you wanted to say now? And don't mention anything. Huh? We're not, this is not mentioning time.
No, Milord. Milord, I am intervener on behalf of the voters. I may be given some time to, Milord, narrate
Mr. Sarode, if you allow interveners, then there'll be
whenever
no
possible,
end to it.
Milord.
There'll be interveners on this side, interveners on that side.
no
Give us
problem.
a small note of a page or so. We'll look at your note. No difficulty. Just
No,
give
Milord,
us some-
I'm supporting Mr. Sibbal sir and the party, Milord. But Milord, voter side is very important as allowed by the honorable
Mr.
court.
Sarodi, Mr. Sibbal will be Mr. Sibbal and Dr. Singhvi will be very happy with your support, but I'm not sure they want you to support them in the courts. You can have a word with Mr. Sibbal. If you have some specific point, which they have not covered, then you can
Yes.
certainly have a chat with Mr. Sibbal and give that point to him, and I'm sure he'll place it before us.
Yes, Milord, I will do that.
Very well then, Malad, Tuesday, I'll take 10 minutes.
Which Brother Narsima has also, we have both been discussing this also earlier. Justice Nariman's judgment on whether there should be a time limit on the speaker to decide
Yes, Madam,
is what
that-
referred.
I was going to cite that, Madam.
If we can,
note.
yeah. And maybe we can
I'll
have some
assist
thoughts
your lordship on that, Malad, on
on
Tuesday
some
for 10
thoughts on
minutes.
that so that
Just
we
note
can.
the reference order is you can note
And then-
2016 SCC online 1875.
Sampan.
That's Sampat, Malad. That's Sampat, not this. This is something different.
Megachandra's separate.
This is
Megachandra's reference.
that the
We'll
other one.
look it up.
The other
The
issue is,
citation.
Malad, where 90 days have been fixed by Justice Nariman for the speaker to decide.
Correct.
That's not that 2016.
Because this is that I just got it from my
That's right.
law club. That must be a separate reference.
That's right.
Considered in that judgment.
Please work on.
Yes.
Lordship, please.
Tuesday.
Tuesday.
Very grateful.
Obliged, Master.
Deeply obliged.